Amid ongoing various cases against opposition leaders or activists based on their social media posts under Section 66A of the IT Act, Ministry of Home Affairs has directed all the state and union territory governments and their DGPs to withdraw FIRs lodged based on Section 66A under the IT Act. Under the state BJP government led by Chief Minister Biplab Kumar Deb and Law Minister Ratan Nath, uncountable numbers of youths were arrested just because they opposed the government's decision or criticized the ruling party members in social media. In Tripura, the level of government's intimidation has surpassed to that extreme that people were arrested just because they had shared a news written against the government's decision. Recently, against various communist leaders, cases were registered after they talked about self-defense. Tripura has indeed made a record-breaking number of cases under 66A in various police stations. But since the Ministry of Home Affairs order, all the FIRs have turned null and void. The centre on Thursday advised the state and union territories to direct police stations in their respective jurisdictions to immediately withdraw the cases registered under the repealed Section 66A of the Information Technology Act. The directive has come days after the Supreme Court expressed shock that the law was being invoked even 6 years after it was struck down by the Apex Court. This comes days after the Supreme Court said it was shocking that people were still being booked and tried under the section scrapped by it 6 years ago. Section 66A of the IT Act 2000 stated that any person who by electronic means sends any information that is grossly offensive or has a menacing character or any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult shall be punishable with imprisonment for a term which may extend to 3 years and with fine. The Supreme Court had in its judgment dated 24th of March 2015 in the matter of Shreya Singhal versus Union of India struck down 66A section, calling it vague and arbitrary. The Home Ministry also requested that if any case had been booked under the repealed section, it should be immediately withdrawn. People's Union for Civil Liberties (PUCL), a civil rights group, had last week informed the Apex Court that 745 cases been tried under Section 66A were still pending before the various trial courts in 11 states of the country. In an application filed before the top court, PUCL claimed prosecution under the scrapped law continued to be in use not only within the police stations but also in cases before the trial courts across India. In some cases, trial courts went ahead with framing charges under the defunctional IT provision. Even after taking cognizance of the court's 2015 judgment, the SC was told SC, while expressing distress and shock at Section 66A still been in use 6 years after it was declared as vague and arbitrary, gave the government 2 weeks to file its reply, and PUCL was given a week to file its rejoinder. In Tripura, opposition political party leaders, editors, journalists faced such cases under Section 66A at a massive number under the Biplab-led BJP government. Bureau Report, Hallabol.